So let us see degrees of prohibited relationship. A man and any of the persons mentioned in part 1. So one class of relatives. And a woman and any of the persons mentioned in part 2 of the said schedule. Another class of relatives. Are within the degrees of prohibited relationship. There is a prohibition to marriage. Correct, my lords? Now the argument was
Cumulate.
to apply both to both.
Cumulate both.
Correct. So the first, that would be necessarily rewriting.
Right.
Lord, second proposition which I must mention here at this stage itself. Lord, would your lordships, I'm posing a question to myself, would your lordships read a particular enactment in such a fashion that it applies in a particular manner to one class, that is heterosexuals, and in a different manner to different class, namely homosexual, I say same sex, the broad category, my lord, we have identified. My lord, that exercise, my lord, may not be a permissive interpretative exercise to create a class within.
Use it. This is what the gesture that I made was. When I'm looking for same sex, I don't wear this. But when I'm looking at heterosexual marriages, I look at it, they act like this. So is this two-way or three-way switch possible in interpretation?
Correct. So, my lord, in my respectful submission, the statute cannot be read to mean A for some class and B for some class. And second, my lord, this is my apprehension, and I must, my lord, share at the outset. And kindly, my lord, examine this a little seriously. My lord, why this degrees of prohibited relationship? I'm not on, my lord, reworking or restructuring.
By the way, interestingly, are these degrees of prohibited relationships pretty much the same as that would are they lifted from the Hindu Marriage Act, or where do they come?
Sagotra and Sapinda relationship.
Yeah, Sapinda is absolutely.
They are now codified, my lord. Because, my lord, apropos, my lord, Justice Bhatt's query yesterday, this entire debate.
Itemized elucidation in the.
Things also.
Yes,
One is the Sapinda, which is you go to the same ancestor, lineal ancestor, and the male linear and the female linear. That originally Shastrik it was 7 and 5. Now in the Hindu Marriage Act it is 5 and 3.
Correct.
Section 5. That is one part where you're talking of uterine blood, etc., where there is blood relationship. There is non-biological relationship also when you're talking of in-laws. So, relationship by marriage. Even there is proscription on that.
That is also prohibited.
It is also there. And this applies equally to all religions and all castes.
My lord, my worry is different. My lord, at this stage, I am not flashing it. And kindly, my lord, listen to this concern, my lord, very carefully. My lord, what is the fundamental argument of the petitioner, which I respect the argument, that it is my right to choose my sexual orientation. Choosing a sexual orientation is
not right to choose sexual orientation. They say sexual orientation is given to me.
I'm on Nautage.
I'm entitled to my autonomy by virtue of my sexual orientation.
Correct.
And a recognition that goes with
Sexual orientation is not a matter of choice, but a matter of immutable features.
My lord,
that's the argument.
There are, my lord, there are two ways, my lord. There are two different schools of thought. One say it is acquirable also. Another say that it is innate, it's inbuilt in the person when a person is brought. Let's not go into that. I'm slightly on a different point. Lord, freedom of sexual orientation is held to be a fundamental right. Someone is attracted, a man is attracted to man, that is considered to be his privacy issue, and he can enter into that kind of a sexual activity the way he thinks he gets the maximum satisfaction. That's my lord, broadly, my wordings may not be accurate or my lord may be proper also. That's that Nautet Johar. Lord, kindly visualize a situation after 5 years down the line, based on this very thing, that from the beginning, I am attracted to those persons who are mentioned in the degrees of prohibited relationship. Incest is not uncommon in the world, and world over, incest is prohibited. That I am attracted to my sister, I get, uh, we are consenting adults, we are entering into uh, activities within the Lord privacy, and we claim our right of autonomy, our right of choice, and our right of doing something in private domain. Based on that very argument, Lord, I'm posing a question to myself. Can someone not challenge this definition itself? Why this restriction? Who are you to decide with whom I have my sexual orientation? It
would
may
be
be, my Lord, a little
that would be
far-fetched.
far-fetched. That would be far-fetched.
Lord,
So
we used
it's
to
obviously a
treat
reasonable restriction. You can't have.
we used to treat even this as far-fetched.
But Mr. Solicitor, sexual orientation or your autonomy as an individual can never be exercised. All aspects of marriage, including the entry into marriage, the prohibited relationships, the grounds on which marriage can be dissolved, these are all subject to regulation by law. So it may be very far-fetched for anybody to even argue before us that that orientation is so absolute that I can therefore commit an act of incest. No court will ever
But suppose
even countenance it.
polygamous marriage.
Forget about sanctifying it, even
Somebody can challenge, my Lord, the bigamy
But
provision.
polygamous marriage, that's again governed by personal law, right? I mean, on the
I'm not on personal law. I'm saying, my Lord, if I say that my choice is polygamy, bigamy, the state has no right to interfere.
Your argument perhaps could be more, I would say, if you're leading up to that, one can understand it. That these are universal rules. I think we can all agree that these are universal rules. Now, as long as they were not codified, they were accepted. And that was the law, that was the norm, that they had a normative effect. Why did the state get into it? The states thought this as a universal norm. Now, therefore, I think if you're building up and saying there is a state interest in this relationship, one can understand. What if you're driving at that this is where the state comes in?
But that's my submission.
Like,
Going to
I think their position too was conceded that when it comes to age also that there is a state interest. So there is no field which is completely autonomous in that sense.
correct.
Even within the marriage bond, there are certain interests of the state which are legitimate, let us say.
Lord, that is, Lord, in the second limb of my submission is going to be that state has no business to regulate social personal relationships. It is only in exceptional cases where the state
that would be also very an extreme statement of law. If they have made that statement,
I'm saying something else, Lord. Can you, Lord? I'll just complete that. State has no business as a proposition to regulate any social personal relationship. That statement your lordships are saying is not a, it's an absolute statement. But on an extension of that statement that the state can regulate certain relationships if the state feels that it's in legitimate state interest to do so.
but of course,
Lord,
yes.
therefore, marriage was not a regulated social relationship, but the state, in its legislative policy wisdom, decided that we will regulate, and we can regulate only if we recognize, and therefore, under the Hindu Marriage Act or any other marriage act, we recognized and regulated. So therefore, that's a legislative choice made. My Lord, leave it at that. But, my Lord, I again, my Lord, I'm insisting, my Lord, that my apprehension may, I wish it's wrong, but may perhaps not be wrong after, my Lord, few years. When your lordships were hearing Navtej Johar, all these arguments were made. The central government, my Lord, said that we leave it to the wisdom of the court so far as the decriminalization of Section 377 is concerned. But I specifically added in my affidavit that this has nothing to do
With marriage.
future right of marriage, inheritance,
Absolutely, no
etc.,
question
etc.
about it.
And I'll just read, my Lord, from
But
page one.
Mr. Solicitor, don't even label that. You have said that. No, we accept your point on that.
So, my Lord, a step from step 7 to 8 may lead from 8 to 9. That's what I am just, my Lord, putting a word of caution. I'll not further. I'll go further.
7 to 8, where you're saying will lead to 8 to 9, there'll be actually 8 to 15.
We can say,
And none of
they
us are
can
looking at
certainly
step 8
regulate
to 22.
social relationship.
The current scenario, Mr. Mehta, or also in the future. The
Not
example
the-
you have given is
My
very
lord, the
much marriage
arguments,
of
the way they are read for marriage,
Yes.
and I'm saying this with a sense of responsibility, can be made, whether
And Mr.
accepted or
Mehta,
not is
I
one
don't
thing,
think we need to.
for challenging incest prohibition
But
as well.
Mr. Mehta, we don't have to labor the point that the state can regulate even social relationships. For instance, a relationship between a parent and a child. Can the parent say, I have absolute control over my child? No, the state says you have to send your child to school.
I leave it at that. My lord,
There's
can
an
we
obligation
take-
to make sure that your
Now,
child
Lord,
goes to
coming-
primary school. That's a relationship between a parent and a child, but we are all subject to the fact that you have to send your children to school. You have to get your children vaccinated. So these are obviously
My lord, now coming back, my lord, to that, your lordships would be required to rewrite. Coming back to the main
yeah,
thing.
let's go and
See, my lord,
yeah.
full blood, definition of full blood and half blood. Your lordships have read, my lord, as hypothetically as requested by them, man, woman, different categories of prohibitions, but your lordship said both prohibitions would apply, and your lordships would bear in mind the petitioners do not represent everyone who is in this particular class. Somebody may say that, no, I don't agree. Why should it apply to both of us? So it would be a risky thing to do. But now full blood and half blood. Two persons are said to be related to each other by full blood when they are descended from a common ancestor by the same wife.
Hindu marriage act दे दो. Hindu marriage act.
इसी में
उसी में है ना? Oh, thanks.
Special marriage act.
नहीं इसमें नहीं.
You're reading from Hindu Marriage Act or
It's
special?
a special marriage.
Special marriage.
Act.
Special marriage act. Two
Explanation 2.
explanation.
Yeah,
to
we
your
say
ladies.
that. Yeah.
That's right.
Yes.
Full blood and half blood. Two persons are said to be related to each other by full blood when they are descended from a common ancestor, that is male, because the next word is by the same wife, and by half blood when they are descended from a common ancestor but by different wives. We can never reconcile this provision because it says biologically one man has given birth to a child through a biological woman. That's what they say. Number two, Lord, marriage between lesbians. This provision will be redundant because she can't have, Lord, full blood. Even if, Lord, there is a child from artificial insemination, it would not be a full blood child. So merely changing man and woman into persons will make many provisions not reconcilable at all. And, my lord, this full blood, etc., will have an inevitable impact on the succession. I'll show. Yeah, my lord, your ladyship's mic is not working.
Actually, then you also see the Hindu Marriage Act, which section 3G. Huh?
Yes. And your lordships may for the time being take it from me that Hindu Marriage Act will apply. I'll show how it applies, even to Special Marriage Act.
Section 3G.
3G. Degrees of prohibited relationship. Two persons are said to be within the degrees of prohibited relationship if one is
Absolutely.
a lineal ascendant of the other. I'm sorry. My lord,
3D. You're talking
2G, 3G.
3G.
Degrees of prohibited, does your lordship get it?
Yes.
Prohibited relationship. Two persons are said to be within the degrees of prohibited relationship if one is a lineal ascendant of the other, or if one was the wife or husband of a lineal ascendant or descendant of the other, or if one was the wife of the brother or of father's or mother's brother or of grandfather's or grandmother's brother of the other, if the two are brother and sister, uncle and niece, aunt and nephew, or children of brother and sister, or of two brothers or two sisters, for the purpose of
they cut out the schedule bit.
There's no schedule.
because
for it.
they improved on it, and I think they worked out the relationship. If you look at this, I think the Special Marriage Act is the template upon
Yeah.
which this was built.
Just a minute. Your Lordships are right. So for them, my lord, they for Special Marriage Act, there is a separate schedule. Here it is statutorily
So
incorporated in the definition. itself.
Definition would
Lord,
incorporate everything there.
Another, my lord, interesting thing, my lord, explanation 3, relationship by adoption as well as by blood. Nothing may perhaps turn on this, my lord, but this is another distinction.
And then they brought in the Sapinda relationship in 3F of the,
Yes, my lord.
and incorporated the prohibition in 4.4 and 4.5. So this is, SMA is a little more elaborate because it then lists out categories which are absolutely within the,
Yes.
they don't leave it to Sapinda, because obviously SMA is religion neutral. Therefore, they itemize the relationships.
But borrowing the concepts from Hindu law,
Actually the same.
borrowing concepts from Hindu
Borrows
law,
it from the Hindu law.
because this Sapinda and Sagotra
Is-
is essentially, my lord, concepts of Hindu law.
Yes.
But in some communities, there is a custom which permits that. And that is also
That is
taken-
excluded, huh? There's an
Section
exception.
4 actually says that, proviso.
Yes, my lord,
The
therefore they
interesting
take
part-
care of that as well.
Actually, anticipating that was brought in only in 63.
Yeah.
63.
Which
But
meant that
by way
for
of an
10
amendment.
years, for 10 years, this prohibition
Prohibition was
continued.
Yes.
So,
So,
for instance,
and,
mama, you
uh,
can, some communities are mama,
Niece,
niece,
Mama
you get it,
and
niece also.
even cousin.
Cousin,
Mama's
sister's daughter.
sister's daughter.
Mama's Banji and son can get married. My lord, possibly, my lord, I
That
inquired,
is
my
still
lord,
protected
That-
because the custom protects.
custom and the custom, the origin, nothing to do with this matter. The origin of the custom was that earlier the daughter-in-law used to be troubled in the household of the husband. So if mama is the father-in-law
Yes.
or fufi is the mother-in-law, then she would be like a child only. So that was the reason why, my lord, this custom.
There were many sociological
There are sociological good reasons, my lord.
Land is another issue.
land
Mostly
probably.
land is the issue.
Keeping the property.
Yeah, yeah,
together.
land is other issue.
Land of the-
Clarification.
My lord, now kindly see 4C. And my lord, read the way they want to read it. It would be as absurd as, my lord, I would sound while reading this, my lord. Please see C. This is a compulsory precondition of a valid marriage under the Special Marriage Act. The male has completed the age of 21 years and the female the age of 18 years. Now we read person. The person has completed the age of 21 years and the person has completed the age of 18 years. It doesn't make any sense unless your lordships rewrites that for same male sex 21 years, same female sex, but then again, my lord, it doesn't take care of other, my lord, categories like transgenders, others, my lord, who are not either male or female. Lord, then kindly see proviso, provided that where a custom governing at least one of the parties permits of a marriage between them, such marriage may be solemnized, notwithstanding that they are within the degrees of prohibited relationship. Your lordship, my lord, kindly leave that and kindly come to, my lord, now section,
Proviso there.
section 11.
4.3.
Section 11. I am showing, my lord, the heart and soul, the basic infrastructure of architecture of Special Marriage Act is between a conventional biological man and a conventional biological female. Lord, section 11, declaration by parties and witnesses. Your lordship gets, my lord?
7.
11, section 11, my lord.
When you go to the third schedule, right? Declaration.
Yeah, I'm sorry, my lord, my learned friend is right, my lord, my learned senior is right. My lord, please see section 4.2. 4.2. Though capable of, this is again a condition, precondition of a valid marriage. Though, B2, your lordship gets, my lord? Though the capable of giving a valid consent has been suffering from mental disorder of such a kind or to such an extent as to be unfit for marriage and procreation of children. The procreation word used statutorily necessarily mean a union between man and woman.
That may or may not be, in the sense, I'll tell you why, that the emphasis in that provision is not on procreation as much as on mental illness.
Correct, my lord. But
Lack of mental
mere
health.
mere mental,
We're getting the drift of your argument, but this point, this particular provision may be a little different actually.
but my lord, mere unsoundness of mind may not be enough if one of them is
I'll tell
ready.
you why, solicitor. In the case of a heterosexual couple, the fact that one of the spouses cannot procreate does not render that an invalid marriage. Suppose the girl
No,
in a
that's
heterosexual
correct.
marriage, suppose she has had a hysterectomy when she was a child, she can still have a valid marriage.
Correct. I take it.
See?
Lord, please come to 11, section 11. And I think my Lord Justice Bhatt saw the form also, my Lord. I wanted to show that form, my Lord. Section 11, declaration by parties and witnesses. Before the marriage is solemnized, the parties and three witnesses shall, in the presence of the marriage officer, sign a declaration in the form specified in third schedule. Please see, my Lord, third schedule. Lord, if we have the same book, it's at page 26.
Yes, yes.
This declaration is to be found, is to be filed.
You're referring to clause 3, not related?
No, my Lord, I'm on the title itself and clause 3 as well. Declaration to be made by the bridegroom and declaration to be made by the bride. The act is not gender neutral. And 3, as your ladyship rightly says, I am not related to CD, the bride, within the degrees of prohibited relationship. So bride's mother is not my relative, etc. Lord, just when your lordships are there, see the second schedule also. Just above the third schedule. The notice of intended marriage. I'm not on the legality of notice, but I'm just showing the gender issue. Your lordships gets scheduled, second schedule. It says unmarried, widower or divorcee. And for the bride, unmarried, widow or divorcee. So not only your lordships will have to rewrite the act, your lordships will have to recast even the forms, statutory forms.
Mr. Mehta, that's in para 1 also of the third schedule. What you're reading in the second schedule is
Yeah.
in para 1 of the third schedule as well.
Yeah, yes, your
Yeah,
ladyship.
you're right. वो वही आ जाता है.
Widower or divorcee or lady.
Right.
Description of the party. No?
Yeah. Which is the next provision, Mr.
Yes. Now, your lordships may come to 19. Lord, I forgot to show, my Lord, during the constitution, this parliamentary debates, one of the debate why, my Lord, this act was enacted was that earlier, the previous Special Marriage Act required me to denounce my religion.
Renounce the man.
Yes, denounce my, on if I get married, my Lord, under this act. And that was working as a deterrent. And therefore, 19 continued, but thereafter it was taken away under 21A. That's the distinction, and that's why, my Lord, I say that personal law gets re-entry through 21A. Please see 19. Effect of marriage on member of undivided family. The marriage solemnized under this act of any member of an undivided family who professes the Hindu, Buddhist, Sikh, or Jain religion shall be deemed to effect his severance from such laws. No, two things.
Just read also, sir, 21, before we read 20.
Only kindly pause here for a minute. 19 says that persons belonging to Hindu, Buddhist, Sikhs, and Jain will renounce they would not be a part of Hindu family, but Muslim personal law continues to apply, Parsi personal law continues to apply, Christian personal law continues to apply, except in succession, which is 21.
That's right.
Yes.
Now, below 20. 20 may perhaps not have much relevance. I'll just read it. Right and disability is not affected by Act. Subject to provisions of Section 19, any person whose marriage is solemnized under this Act shall have the same rights and shall be subject to same disabilities in regard to the right of succession to any property as a person to whom Caste Disabilities Removal Act applies. The caste, my lord, were recognized earlier, and that there were certain disabilities which were removed. So, my lord, that rightly, my lord, in the present context, my lord, may not have much relevance. Please see, my lord, 21, where Succession Act is made applicable, Indian Succession Act, across religion, but not other personal laws of Muslims, Parsis, etc., my lord, and Christians, my lord. Not, I'm on 21, my lord,
Yes.
Chief Justice, my lord, wanted. Notwithstanding any restrictions contained in the Indian Succession Act, with respect to its application to members of certain communities. There are chapters applicable to Parsis, Christians, etc. Notwithstanding that, succession to the property of any person whose marriage is solemnized under this Act and to the property of the issue of such marriage shall be regulated by the provisions of the said Act, and for the purpose of this Act shall have effect as if Chapter 3 of Part 5, Special Rules for Parsi Intestate, has been omitted. So, my lord, Muslims continue to govern by their personal laws,
Yes.
except in case of succession. Now, my lords, personal laws even for Hindus, which were taken away in 19, comes back in 21, because they found that this is deterrent.
Personal law, no? 21. See, the thing is for 21 years, they realized that this is working
To the it's deterrent.
deterrent.
Deterrent. That I want to marry under Special Marriage Act, but I don't want to renounce
And
Hinduism.
eventually you might be accepted by a family
Yes.
and you are cut out. So therefore,
By law, I am cut out. The society, my family would accept me, and
but law, you're excluded. Therefore,
yes,
they brought it at par. So in that sense, there is equality among all.
correct. So, my lord, where the marriage is 21A, solemnized under this Act of any person who professes the Hindu, Buddhist, Sikh, or Jain religion, which a person who professes the Hindu, Buddhist, or Sikh or Jain religion, I have to marry Hindu only. Then only 21 would apply. Section 19 and 21 shall not apply, and so much of Section 20 as creates disability.
21A lifts the prohibition or the
19.
disability which is created by 19 only where a person who's a Hindu, Buddhist,
Marries a Hindu.
Sikh marries a Hindu, Sikh.
Yes.
So if you marry outside your own religion,
You're cut out.
you're still cut off from the system.
19. Then 19 applies. Suppose I marry a Muslim, just giving my example.
Yes, you're right.
Then, my lord, 19 would
You're
govern.
right.
21A would not.
There's one more thing, apropos your submission, to stretch it to a further extent, that 19 provides for severance only in respect of your family status, of the marriage solemnized under this act of any member of an undivided family who possesses these four religions.
I lose co-parsonary rights.
Right. But there's one very important thing. So you lose your co-parsonary rights. In respect of all other aspects, you are still governed by your personal law.
My personal law. Yes.
So despite 19 having said you lose your severance, there'll be a severance from the status of a family, 19 still holds intact the applicability of all other aspects of your personal law.
Correct, my lord. I'm obliged, my lord. That's the submission, my lord. Therefore, my lord, I have been respectfully urging that it may not be a choice while examining Special Marriage Act not to touch personal laws.
It's
That's-
intricately interwoven with.
It is
The
interwoven.
moment you get into 21A even,
Yeah.
or even 19, succession is governed by the Hindu law, whatever it is. If it is Hindu, Hindu law. If it is someone else there, that concerned personal law, willy-nilly creeps in.
Yes.
So section 21(1)A is
You're right.
like that wormhole into which everything comes in.
Lord, in fact, this is a comprehensive exercise. Apropos your Lordship's query, yesterday we checked up that from 52 to 54, 50 to 54, Lord, the entire debate was Hindu Code Bill, and this was a part of that very Code Bill.
And then they finally
Yes.
they bifurcated it
Thereby, yes,
into three parts.
into three parts. Lord, for Hindus, uncodified became codified, and for others, Special Marriage Act came. And Lord, there is an interweaving of Lord, the provisions, interweaving, Lord, I'm sorry.
As they say now, there's some kind of a cognateness to these enactments.
Yes.
Cognate.
So they are all, my Lord, intertwined. My Lord, I'll just read. My Lord. Lord, I'll give the Lord, a report, Law Commission's report, which we could find out
Yes.
yesterday
Yes.
when 21A was introduced. My Lord, I'll
This is interesting.
place the copy, my Lord. It is in 59th report of Law Commission of India, but they quote the select committee recommendation when 21A came to be introduced.
Do we have that in a compilation?
Is it there in volume 1?
My Lord, it's not there. I'll just check, my Lord, because we yesterday, my Lord, tried and find out. I'll give the
It's the 59th report, huh?
59th Law
59.
Commission report.
Select committee.
No, my Lord, Law Commission's report, which quotes select committee.
Yes, he has not filed.
इसमें मिलेगा. It's Justice Gajendra Khatkar's report, huh?
Yes, yes, my Lord. No, it's not there, my Lord. I'll, my Lord, place it within 10 minutes.
All right.
Allow me to
Just
read.
read it.
In the documents folder.
Volume 10.
Mr. Solicitor, just read it out. It will be a short one paragraph.
There is one paragraph, my Lord.
Just read it, that's all.
Why 21A was brought in. It may not be necessary to shuffle through, my Lord. I'll just read, my Lord. In our opinion, that the select committee says, in our opinion, it is desirable to exclude from the scope of this section cases where both the parties are Hindus. In such cases, the law of succession, otherwise applicable, should continue to apply. We see no reason why the fact that the parties choose to marry under the Special Marriage Act should make a difference in such cases, i.e., where both are Hindus. We recommend that such cases should be excluded from Section 21.
Oh, I see.
Yes. Lord, the reason was, Lord, registration of a marriage has never been compulsory. Even today, it is not compulsory. It's a personal choice, whether it is under the Special Marriage Act or under the Hindu Marriage Act or under any other marriage act.
Registration, but it does not make it valid if you don't register.
I think now they have.
Correct me, I think it is compulsory, but failure to register does not render the marriage void or an irregularity.
Compulsory.
Maybe, you know, it depends. But
Hindu Marriage Act is not compulsory.
Is it? No?
It's not.
And what is
but my Lord,
Special Marriage Act?
the deterrence was,
Yeah, that is meant for registration.
Lord, there were many marriages in those days when this 21A came, which were solemnized.
You can inquire from across the people in the court how many have marriages.
My learned senior says these marriage is not registered.
Same here. Same here.
Where is the proof, Mr. Dwivedi? Where is the proof?
He'll raise our hands.
No, we
If I'm not wrong, I think this compulsory requirement of registration of marriage was introduced a few years back when they
Yeah,
said
recently.
even if you are married according to Hindu law or any other thing, you must
Yes.
register your
My
marriage.
lord, earlier what used to happen, the marriage would be, my lord, solemnized as per Hindu rites, Saptapadi, etc. Not under special marriage act. But I want a certificate of marriage. So, therefore, my lord, it became a deterrent. That if I take certificate, I'll not be governed by Hindu Succession Act.
Right.